of this honorable court deal with cases under the Firearms Act. Mr. Chairman, in this Ageesigika case, which is again reproduced in the subsequent decisions which I've just made reference to, particularly the one of Senate. So, clause 4, paragraph 4 of the decision. No, paragraph 3. Military law under the UPDF Act must be construed to exclude the laws that are the reserve of civil courts of judicature established under Chapter 8 of the Constitution. And Mr. Chairman, this was a reinforcement of the decision in the case of Dr. Kiiza BSJ, the very person before you here, in Constitutional Petition number 12 of 2006, where it was adequately, again, handled by the Constitutional Court, that the offense is not the one whose particulars appear in the charge sheet. The offense in the charge sheet is under Section 3, by then it was Section 3, now Section 4 of the Firearms Act. That offense does not fall under Section 119. I'm sorry, it may not be that clear, the photocopy was not clear, Mr. Chairman. That offense, Section 3.1 of the Firearms Act, which is now Section 4 of the Firearms Act, and it canvasses count 3, 4, and 5. That offense does not fall under Section 119 of the UPDF Act. The offense of unlawful possession of firearms, ordinarily the monopoly of the UPDF forces. They say this offense is neither defined by any law in our statute books, nor has the sentence for it been prescribed. The said amendment of the charge, there was an amendment to the charge sheet, is clearly not helpful. They went ahead to say that government, or UPDF, attempted to come up with instrument number 13 of 2006, ostensibly, I think, to address that lacuna. Uganda People's Defense Forces, arms, ammunition, and firearms, to define that phrase, monopoly of the defense forces. The court said that instrument was also redundant. And the beauty with this, my learned friend here was still the judge, was involved in this matter and is fully aware of the facts in this particular matter and all the attempts that were made to address those legal challenges. In other words, their finding was that you cannot widen the scope of Section 119 to bring into operation the provisions of the Firearms Act or any other law, including the Suppression of Terrorism Act, which is a reserve of the civil courts. That would be overstepping the mandate of the General Court Martial. I can say incarnation of the same here in this very charge sheet. So what ordinarily ought to have been done is to define that animal, which clearly, the animal called offenses which are ordinarily a monopoly, no, weapons rather, weapons which are ordinarily a monopoly of the UPDF. Up to now, ever since this decision was made, the BSJ decision, this animal is still anonymous, undefined. And the attempt to do so in this instrument were also declared futile. So, Mr. Chairman, unless and until that phrase is unpacked and clearly dissected and explained, this General Court Martial cannot try offenses under the Firearms Act. So, we would like that issue again to be also canvassed by the Constitutional Court. Finally, the issue I would raise is whether the arrest, conviction, and the detention of counsel Eron Kiiza, one of the defense lawyers, amounts to violation of Article 28.3 of the Constitution. Mr. Chairman, Eron Kiiza is on record up to the present moment is one of the defense lawyers. And I'm glad when we raised it here and said, how do we cause the appearance of Eron Kiiza to execute his duties as per the instructions given to him and as per the record? There was preponderance of doubt. I read it on the mind. If I read you right, Mr. Chairman, he said, is there a precedent in this? Did it happen that a person convicted can also come here? Then the judge advocate was of similar doubt. The only forum where that doubt can be cleared is the Constitutional Court. And the Constitutional Court has had occasion, this is the last authority I'm citing. In this case, it's one of the locus Giraskas case on rights, fundamental rights, Article 28. Uganda Law Society and Jackson Kangaba versus the Attorney General. The lead justice, I think, was quite right. They gave a purposeful interpretation. Of course, this is the command of the Constitution and rules of interpretation to Article 128. Each and Article 28, rather. Each and every of the above Constitution, each and every of the above, rather, not of the above Constitution, each and every one of the above constitute what the right to a fair hearing means. It was never intended that this would be an exhaustive definition of the right to fair hearing. Article 45 of the Constitution provides human rights and other freedoms addition to these rights. Mr. Chairman, during the trial here, during the hearing of the prayer we made about the appearance of our colleague Eron Kiiza, the judge advocate here indicated and said, but you see, Article 28 talks of the right to legal representation. It does not specify the numbers. The answer lies in this decision. That Article 28, which talks about the right to a fair trial, is not even exhaustive when it talks about those key elements. It's the reason the CA had to insert Article 45. That there are situations that may arise that would warrant one to enjoy more than what you can even see. Why Eron Kiiza is indeed needed in this case can only be answered by the person who gave him instructions. He knows the reason and he should be facilitated to prepare his defense. And one cannot say, just especially from the other side, from the judge advocate, that what role is he going to play when the accused person has got over 30 or 40 lawyers. The prerogative rests with him to determine who should be there, who shouldn't be there, and to have a lawyer or lawyers of his choice. That is the language of the Constitution. Eron Kiiza remains his lawyer of choice for a reason which should not be derogated, because that is a non-derogable right. The right to fair hearing, Article 28 and 44, is a non-derogable right. So I reiterate the prayers made. I will not go into other issues. I beg that Mr. Chairman and honorable members that you proceed to do what is commanded by Article 137 to refer this matter to the Constitutional Court. I beg